Warmest of welcomes to our closing international roundtable for human rights, sustainable development, and the law 2026. It has been a full and remarkable day. From the climate emergency before our regional and highest courts to human rights in business, trade, and investment for sustainable natural resources management, to the celebration of 2 extraordinary legacies and the welcoming of a global fellow and 3 new WIJA laureates, to the rights of Indigenous peoples, of generations to come, and of nature itself. And through all of this, hundreds of you, I've been told more than 1,800 have joined us online at different moments during the day, from over 140 countries, have continued alongside us. Our task now is to gather these threads into something we can carry forward. And to guide us, I am very pleased and also a bit relieved to be able to turn to my co-chair, Professor Nandini.
Thank you. Thank you very much, Professor Marie-Claire. As you say, it has been an extraordinary day of invitation to think about accessible solutions to address challenges facing our collective future. The chairs of our 3 expert plenaries have kindly stayed on with us to reflect upon and to summarize, synthesize the wealth of insights shared across today's sessions. I warmly welcome and invite Dr. Ashfaq Khalfan and Advocate Ayman Cherkaoui, Professor Markus Gehring, and Professor Ilaria Espa, Professor Maya Prabhu, Professor Jorge Cabrera, and Dr. Pamela Towela-Sambo, and for you to help us sort of grapple with what all has been said during the course of this extraordinary day. And the guiding 2 questions, I think, are how can international law promote and protect human rights for a more sustainable world? So it's broad, big questions, and we invite you to share your insights from your panels and your own insights. And the second question is, what are the emerging trends, the most innovative instruments, and most promising developments in international human rights law and policy to advance United Nations Sustainable Development Goals? So I turn over to you, Professor Marie-Claire, and you can...
Sure, absolutely. So I will turn first perhaps to Professor Maya Prabhu and also Dr. Pamela Towela-Sambo and possibly Professor Markus Gehring. If we could begin with you on our first question, how can international law not merely protect human rights, but actively advance them in the service of a more sustainable world? If Maya is not online, I will turn directly onward to Professor Markus Gehring and Dr. Pamela Towela-Sambo. Please go ahead.
Thank you so much, Marie-Claire. It's a fantastic opportunity to share some of the insights from our panel earlier. And what was very clear to us was that human rights and sustainable development are now intrinsically linked. They have an impact on areas such as international trade and investment. And in particular, human rights compliance doesn't stop with states or governments. Companies also have to comply with international human rights laws, and they have to do that in the context of sustainable development. We discussed issues ranging from critical raw materials, the just transition, the impact of the advisory opinions on international trade and investment, and how sustainable development could be fostered rather than frustrated by international rules that concern international trade and investment. We also discussed the important elements of the impact of these rules on communities on the ground, on indigenous peoples around the world, and local communities. There is, in our view, no valid trade-off between economic growth, economic impact, and pursuing the Sustainable Development Goals. They all go hand in hand. And while economic activity can be one of the tools, it does require careful regulation, and ignoring fundamental rights, ignoring human rights, could be to the detriment of achieving the Sustainable Development Goals. That was, I'm not doing full justice to our rich discussion, but those were some of the thoughts I took away from our panel. Thank you very much, Michael.
Excellent. And Dr. Pamela, would you like to add a few insights from the fascinating panel that just finished?
Okay. Thank you so much, Marie-Claire. I think as we come to the close of this very important engagement, we have re-emphasized that human rights, sustainable development, and the rights to nature, as well as the rights that accrue to the indigenous and local communities, are all inseparable. I think one of the key issues that came out throughout the engagement in the session was that there's a need to domesticate all the different standards that we have in international law and get these into our local systems, whether they be separate laws, acts of parliament, or indeed through the constitution. I think when we looked at the case of rights of nature, we noted that a number of countries have domesticated them through nationally approved standards in their constitutions, in their legislation, and the impact has been wonderful in terms of linking human rights as well as environmental governance. So when we move now, as we try to summarize what has been discussed in all the different sessions, I think it's important that we keep re-emphasizing the need to domesticate these international standards. I think once this filters to local communities in the different parts of the globe, we will eventually move towards a more sustained approach, which then reinforces what we have done at the international level. So in terms of how we move, there is need to also strengthen the use of already existing mechanisms. For instance, environmental governance generally has grown in most countries over the last few decades. What we need to do now is to strengthen those systems upon which environmental governance has grown and feed them into the process of linking to the SDGs. Because all these processes are linked. The SDGs are rights-based, and environmental governance in about almost all the countries across the globe are linked. So it is very important that before we start to discuss new standards, we try to fuse these principles, for instance, of free and fair, free and prior consent in terms of indigenous persons. We look at human rights-based environmental governance across the board, across all the different sectors of the environment. I know in the previous session, we had a question which I found really interesting, and I want to build up my reading on it. How do we use rights to nature beyond just climate change? Because it seemed the focus had zeroed on climate change. So the emphasis, I think, should be across the divide of environmental sectors. We need to spread into the water sector, into forestry, into pollution control, just about everything that is environmental, so that there is a strengthened approach rather than a sector-specific approach. Further, I think it's important when we look at some of the aspects that are already settled. For instance, when we look at the right to a healthy environment, a clean, safe, and healthy environment, it is broad, and again reinforces the point that I have made, that we should stop being sector specific. We should go flat out and move beyond our national jurisdictions to the global platform and ensure that all these issues that we are talking about at international level have a top-down and bottom-up approach. So we need to make sure that as we look at aspects, as I mentioned, the right to a clean, safe, and healthy environment, we need to break them down and incorporate what exactly they mean for human rights, for sustainable development goals, indigenous people, and all the people around the world. Eventually, as we do this, it's important for the message to crystallize, to become a way of life. So when we look at the cliche of leaving no one behind, it really must be meaningful that we leave no one behind in the real sense of the word. We have different vulnerabilities that are addressed from the different perspectives that we address through human rights, and which feed into sustainable development. And ultimately, the law is not just an abstract instrument. It links all these challenges and the resolution that we have. So I think we have had a very good discussion across all the sessions, and feeding all this into these concluding remarks is really going to have practical outcomes. And this is, I think, what we all hoped for as we started out earlier in the day. Thank you.
Thank you to both Professor Gehring and Dr. Pamela for your insights, rich insights here. And I'll turn to Dr. Khalfan, Advocate Cherkaoui, if you are there. Perhaps you're not there. Professor Espa, I see you. And am I missing?
Dr. Fabiano.
Dr. Fabiano, we invite you to perhaps engage with the second question on the emerging trends, innovative instruments, and promising developments now in advancing the Sustainable Development Agenda.
Okay, I guess I'll start. So some of the promising instruments, I think, this is captured also in the last panel, that I think what Judge Szabo said really, I think, made quite a lot of people stand up or sit up. The point about non-regression being a constitutional benchmark. So that's very interesting. Another aspect was the point, and this is maybe not it depends on whether you consider an ICJ decision and a new decision, but it was really interesting how Judge Sibet pointed to its main role as being one of influencing domestic courts. I think that potentially helps with the domestication challenge that Professor Pamela just indicated is a huge priority. But that's one of the main ways in which some of the impact of that decision is being felt. And I think Jorge also emphasized that with a few examples from his context. So that's interesting. But of course, there's much to be done. The decisions didn't necessarily go or perhaps couldn't go as far as would be needed to meet the full requirements of small island states and other states in terms of climate finance and more and greater ambition and speed and in defossilization, to use the word. framed by Elisa Morguera. And so there were at least 2 references to contentious cases before the ICJ. So that's really exciting. That's really interesting. That's why there have been calls for the UK to pull out of the compulsory jurisdiction of the ICJ. Some of you may have seen that, specifically to prevent these forms of cases. Let's hope that doesn't happen. There were a few points. There was, at various times, the reality check came in that there are many threats to multilateralism, but at the same time, and this goes to the opening panel, and yet we still see new treaties being formed. The beyond the biodiversity beyond natural jurisdiction treaty, the tax convention, which mentions sustainable development as a principle, still being negotiated. So there are, it's really interesting. We have hope and despair at the same time, and we had a very hopeful former special rapporteur and a deeply pessimistic current special rapporteur who pointed, and the example she gave, this is Elisa Morguera, about how safeguards, the whole language of safeguards, the whole practice of safeguards, for even in regard, as in human rights safeguards to climate change mechanisms, is that their human rights are often seen as an add-on. So in the first panel, there was a huge amount of optimism about human rights and its application to new areas, though with some degree of caveats, useful caveats. I think the point wasn't necessarily made, but perhaps comes through that human rights should actually be a way to increase the political popularity of environmental and climate change measures, with a view to sustaining the political support for them over political cycles. The problem is that helps certainly in terms of numbers, in terms of voters, but it doesn't necessarily help you with elite opinion and moneyed interests, which often play a huge role in political decisions as well. So the first panel, lots of optimism, and it's in stark contrast to the second panel, where there was a lot more pessimism about, or not pessimism, but examples given about how human rights wasn't actually really being fully taken on board in investment and trade. And so I think Markus may want to come in again after
Ilaria's here.
And Fabiano, after Ilaria and Fabiano, Fabiano may want to comment on this as well. But it was interesting, and I'm not sure whether that simply just reflects the way things are, or whether there was a bit more Pollyannism on the first panel, and more realism in the second panel. Whether that really just reflects the field. I think it's the latter, but I'm very keen to hear what the fellow co-chairs think about that.
Excellent. I'm going to turn straight to Professor Ilaria to give a few views in terms of innovations, emerging trends, promising developments.
Can you hear me?
Yes, we can.
Yes. Thank you so much. And indeed, I like the expression that Ashfaq used, open despair. I think that very well reflects also a little bit the mood of our plenary. But I think, apart from the gloomy picture that, of course, the current geopolitical constellation gives us, especially when we look at what happens in the trade and investment regimes and the risks that regulatory fragmentation entails. I mean, I think we had a number of speakers which, of course, spoke about the risks inherent in, pursuing sustainability objective through uncoordinated approaches, and in particular unilateral measures that, of course, bring lots of resistance, lots of skepticism, and of course, a lot of controversial implications, especially when it comes, to calls of green protectionism in disguise, for instance. There's also been a message of hope that really lies in the need to pursue an approach that Professor Gonthier, for instance, mentioned of multi-level governance. In particular, I think this also resonates with what Dr. Pamela said about the need to ensure that action is not just pursued at the international level, but is really brought down at all levels, from local to global. And this, of course, reinforces the regulatory coherence and mutual supportiveness between different regimes, right? So this was really a point that emerged very clearly from our discussions that, you may have, very strong language, but to the extent that you are not implementing those commitments and enforcing those commitments at a local level and the national level, of course, then those obligations are going to become ineffectual. So I think in our case, there was, lots of emphasis put on the need to operationalize through collaboration and mutual reinforcement human rights obligations at all levels of governance. And this was the way to go forward. And I think emerging trends gives us hope in this respect. So we would like to end on a positive note.
Thank you very, very much. And thank you especially to Professor Markus Gehring, to Dr. Pamela, to Dr. Ashfaq, and also to Professor Ilaria for helping us to understand and bring forward some of the main messages that have become very clear throughout the day, despite the incredibly difficult and broad questions we've been asking you. As we move toward the close of this extremely rich, substantive, and indeed fascinating symposium, I'd like to invite reflections from colleagues and partner organizations whose work has done much to shape this field. And in particular, we invited two of our Canadian partner organizations, the International Law Association of Canada and the Università de Montreal, Faculté de Droit, if they would be kind enough to give a few remarks at the end of the symposium rather than the beginning, because it seemed rather unfair to invite and ask colleagues such as the Qatar-based HBKU UNESCO chair to stay until midnight their time in order to give a few remarks to close. So they kindly agreed, and we're very, very happy to have them here to help us to close the symposium. It's a particular honor to welcome Dr. Una Fitzgerald, President of the International Law Association of Canada, and a senior fellow of the Human Rights Research and Education Center at the University of Ottawa, where she teaches on human rights in the Faculty of Social Sciences. An extremely distinguished international lawyer, she served for many years at the most senior levels of the Government of Canada, including as a National Security Coordinator for the Department of Justice and as legal advisor to the Department of National Defence and the Canadian Forces, before directing the International Law Research Program at the Centre for International Governance Innovation. A prolific author and editor whose work spans human rights, Indigenous peoples' rights, climate change, corporate responsibility, and trade and investment, she has most recently pioneered a transdisciplinary practice, bringing international law into dialogue with the arts. So, Dr. Fitzgerald, warmest of welcomes. The Zoom camera is yours.
Thank you so much, Marie-Claire, for that very kind introduction. And thank you, Nandini, for chairing this last panel. It's my pleasure on behalf of the International Law Association of Canada, as a co-sponsor of this conference on human rights, sustainable development, and the law, to just contribute a few words of appreciation for this amazing conference and the wonderful speakers that you've had. Let me just tell you a little bit about ILA. ILA Canada is the Canadian branch of the International Law Association based in London, England, and founded in Brussels, Belgium in 1873. With over 5,000 members worldwide, our collective objective is to promote the study, clarification, and development of international law, both public and private, and the furtherance of international understanding and respect for international law. So obviously, we are very supportive of this conference where you're exploring where are the new directions in international law and how is sustainable development, how are the sustainable development goals being integrated. So we've seen, and we just heard in this final panel, that the SDGs have been challenged over the last few years, first with the pandemic and secondly with geopolitical tensions. However, amid the despair that's been noted about the future of international law, there are rays of hope. We've seen over the last couple of years that international tribunals have recognized the core responsibility of states to protect human rights, to ensure that corporations comply with human rights and to cooperate with other states in the protection of human rights. In theory, not necessarily in practice, unfortunately, in many cases. Environmental degradation and climate change threaten the fundamental human right to a healthy environment. This is most pronounced for peoples who depend on the natural environment for their livelihood, such as indigenous peoples and tribal communities, as well as fishers of the lakes, rivers, and oceans, and cultivators of the lands and forests. Further, the Inter-American Court of Human Rights has recognized the rights of nature are intertwined with and integral to human rights. So, as has been suggested today, we need to see this evolving, encompassing notion of human rights integrated into domestic law, international law, bilateral and international relations, as well as in corporate governance. This integrated approach, combining the pillars of human rights, environmental sustainability, and economic development, will enhance the chances of success in achieving the SDGs. As an example that helps provide some guidance, the UN Declaration on the Rights of Indigenous Peoples, with its notion of free, prior, informed consent, provides some guidance as to how to integrate a more nature-based approach to our concepts of prosperity. Other examples of mutually supportive regimes are helpful here too. So just to say, I think this is a really important reflection that you folks have had today. I thank the audience and I congratulate all the organizers for this fascinating conference. So on behalf of ILA Canada, thank you very much for your participation. Back over to you, Marie-Claire.
Thank you very, very much, Dr. Una, and thanks also to the International Law Association. We've seen many of the international lawyers and jurists from the ILA participating over the course of today, and indeed it is a pleasure to have the International Law Association of Canada as one of our founding partners in this event. Now, it's also a true pleasure to, of course, welcome Madame la Professeure Constantia Kutuki of the Faculty of Law of the Université de Montréal, who has served for many years as lead counsel for natural resources in the CISDL and also as executive director of the Normalmente Institute here in Montreal. A distinguished international jurist, her research illuminates the connections between international trade, intellectual property, and environmental protection, with a profound and enduring commitment to the social and economic and cultural development of Indigenous and local communities, including indeed fisherfolk. And so, having spent much of her career as a guest and researcher among such communities across the world, we are deeply grateful that she can bring a rare depth of understanding to the governance of natural resources, preservation of natural spaces, safeguarding of traditional knowledge and rights, medicine, agriculture, ways of living well upon the land. Professor Kutuki, are you able to unmute and join us now?
Yes, I was just trying to save you the background noise. I was supposed to be much further than I am, as I had mentioned, because of tomorrow's event. I had mentioned that I'm on for my kids on a competition route, and we were supposed to be in Halifax already, but unfortunately we are in northern New Brunswick, where there's no signal. And so, yes, I would love to turn on my camera, but if I do, you will lose me. So I will not.
All right. So
northern New Brunswick is what it is. It's gorgeous, but the signal is simply not there. So I will make this brief before I lose the signal altogether. I was very impressed by all the panels today and all the comments and all the interesting reflections that were being made. And in many other CISDL sponsored events, we hear often these types of reflections. And I think it's important and very interesting to have this group of people reflect together on these very important issues. I would like to base my point on something that I think is quite important to me, and that is something that's a little bit left out, I think, from these discussions, and that is how we view nature and how we view how, I guess, science is now coming to understand nature, which was not the case when sustainable development laws were being conceived. And even today, on the international level, we rarely bring these aspects into play when we discuss what the legal frameworks are going to be around sustainable development and human rights. And that is the fact that although we always considered language, consciousness, all these things as being particularly human, it is simply not the case that we are now realizing. We are realizing that fungi networks across the world have discussions that we can't even imagine, and that trees have their own language, and that various other species have linguistic capacities that are far, far more complex than what we understood them to be before. And I think in discussions with regards to concepts like human rights and sustainable development, I think we need to open the door in the international level to bring in these new sort of scientific discoveries about how nature and different elements in nature actually are much closer to what we consider humans or humanity only type capacities than we thought before. And what do we do with this type of information now that we have it? Because we can't really ignore it. And, there was a big thing that a little town next to the town I live in made it to international newspaper headlines. So Vaudreuil-sur-le-Lac just decided that trees actually have rights. And so it's probably the third or fourth jurisdiction in the world. And it's always small towns that sort of do this sort of thing. But what was interesting was to read what they based their decision on. And this was very, very scientific, peer-reviewed, et cetera, documents that demonstrated the tree's capacity to actually talk to their offspring, if we can call it that, or to their neighbors, or so and so forth. So I would just sort of put it out there that human rights and sustainable development needs to sort of push a little bit the envelope and take into consideration these newfound or new known, I guess, capacities of the natural world. Thank you very much.
Thank you very much, Professor Constantia Kutuki. And indeed, you're right to pick up on that point that was also raised in the final plenary on the rights of nature. I do note scientific articles coming out just recently, finally recognizing that cetaceans, dolphins, whales, orcas, each have their own name of whistles and bubbles and song. So thank you so much for those words of wisdom, Professor Constantia, and thank you also to the Université de Montréal for your enduring partnership in the Gonthier lectures as part of the Gonthier Memorial Commission, and indeed in co-hosting these biennial symposia every 2 years. I'm going to ask Professor Nandini Ramanujan now, as my co-chair, to perhaps lead the very last part of this discussion, which is, of course, an opportunity to hand over the baton to the representatives of future generations of scholarship in a different way, which is, of course, our partner law journals.
Thank you. Professor Marie-Claire. So we would like to recognize to begin with, 2 student-led journals at McGill showcasing and disseminating cutting-edge, innovative ideas and scholarship in international law, international human rights law, sustainable development law. And particularly, I'd like to underscore the faculty's strength and tradition, which is legal pluralism. And I think the journal Inter Gentes actually represents that element particularly well. So I'll turn to Randa Omar, who's far away and it's very late for her, but she has graciously come online to speak to us. And she will represent, or she is representing 2 journals, Inter Gentes and the McGill Journal of International Sustainable, I don't know, it's a long name. McGill Journal of International Sustainable Development Law. I have published in the journal on more than one occasion, but I still have trouble sequencing different words.
They changed it at a
Yeah,
point.
so Randa, over to you, and then I will turn to Dr. Eghoza Ekator for his brief remarks.
Thank you so much, Professor Nandini. I've actually returned to Canada a little earlier, so it's not that late. So again, thank you so much for having me, dear honored chairs, distinguished guests, and participants from all over the world. It's an honor to be amongst you today and amongst so many of my teachers and so many jurists who I look up to. To give you some context, I've just completed my 2nd year of the Joint Juris Doctor and Bachelor of Civil Law program at the McGill Faculty of Law. Before law school, I worked as an architectural designer specializing in sustainable institutional projects and later in Indigenous and anti-racism policy, notably at the Ontario Ministry of Indigenous Affairs. So these are the experiences that led me to my current editorial work and as well as my research work on disability inclusive climate action under the supervision of the McGill Law Associate Dean of Research, Professor Sébastien Jodouin. It's my pleasure to be making some closing remarks for today's symposium in my role as the co-editor-in-chief of Inter Gentes, which is the McGill Journal of International Law and Legal Pluralism, and as senior editor of the McGill Journal of Sustainable Development Law. The name Inter Gentes refers to the law between peoples, but it also refers to legal thinking, knowledge, and dialogue between peoples. It rests on a belief that we learn best from each other. And I believe that we only have hope of addressing sustainable development and human rights issues if we have the humility to learn from each other, to ask for help, to know when to turn to other frames and worlds of knowledge. So this name Inter Gentes is a mission statement. We believe the most impactful legal thinking happens in the space between disciplines, between languages, between ways of knowing. That's why the journal publishes in English, French, and Spanish, drawing scholars, jurists, and professionals from across the world into the same conversation. The McGill Journal of Sustainable Development Law shares the same spirit. It serves as a forum for the world's leading scholars to exchange ideas on the intersection of law, development, economics, society, human rights, and the environment. It publishes high-caliber scholarly articles in both English and French on sustainable development law, offering a space for critical analysis and debate across jurisdictions and across the very themes we've spent today discussing. And though as editors we take on leadership roles, these student-run journals also allow us the privilege of being students, to learn not only by engaging with the themes of the journals, but by working with one another, thinking through ideas, and working to communicate them most effectively. The symposium has hosted exactly the kind of dialogue we aspire to foster. In our conversations today, we've moved across jurisdictions and architectures of rights. What ties them together is something several speakers returned to today, that a rules-based, rights-based international order should not be a luxury of stable times. It is most needed precisely in times of instability, that compliance cannot be seasonal, it cannot bend with election cycles, and it cannot be built without Indigenous knowledge and leadership, or without meaningfully involving the future generations who will inherit the consequences of what we decide today. These are the learnings we will take to our next journal volumes. So if you're interested in continuing this dialogue and submitting your work to us, both Inter Gentes and the McGill Journal of Sustainable Development Law are welcoming submissions from scholars and practitioners alike. We'd be honored to receive your work, and we encourage you to take a look at our submission instructions on our websites and to reach out with any questions you may have. On behalf of the editorial teams of both journals, thank you to CISDL, to the McGill Center for Human Rights and Legal Pluralism, and to all the distinguished speakers and participants who gave us their time today. You've generously reminded us that we do indeed learn best from each other. And as I zoom in from Toronto, the place where trees stand in the water, and the traditional territory of many nations, including the Masagas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, I want to say Chimigwech, Niawen, Tiwank. Thank you.
Thank you, Rhonda. Thank you for such eloquent and thought-provoking remarks. Much appreciated. And I now turn to Dr. Eghosa Ekator, who will speak on behalf of Journal of Sustainable Development Law and Policy. I invite you to make your brief remarks towards the end of this extraordinary symposium.
Good evening, everybody, and thank you for inviting me to this event. And from my perspective as the Deputy Editor-in-Chief of the Journal of Sustainable Development Policy and Law, we try to represent Global South sort of perspective on the various issues. And I've been an editor for, I think, about 3 years now. The volume of publications we're seeing regularly. And I think about a month ago, we did a special issue on legal education in Nigeria, and it was launched by the Nigerian Bar Association Legal Summit event. And you had like the Director General of Nigerian Law School, a lot of people came in. So in terms of the journal, not just maybe publishing articles, we're having some impact on the Nigerian legal community and Nigerian society. So sustainable development is also something we do in the classroom, or we do at UNESCO, the United Nations, something that affects lawyers, that affects teachers, that affects the ordinary person. So as academics and as a journal, we try to bridge that gap as well in terms of what we publish, where we publish from, and it's an open access journal. So, and it's also a Scopus Index journal, Q3 rating as well. So we try as much as possible to ensure that voices, different Global South voices, are heard from the journal. So thank you for the opportunity. Hopefully the collaboration will continue. Thank you.
Thank you very much to you, Dr. Ekator. At this moment, I would like to extend thank you to everyone who's contributed to today through in extraordinarily different ways in organizing events, moderators, interveners, contribution to ideas, and in so many ways. So deeply grateful to all of you. And it is, we are coming to the closure of the 2026 Online Global Symposium. And on behalf of all of us, our gratitude goes to speakers, chair, and partners, and above all, thousands of you. I think numbers are in thousands who have attended this symposium and made this day extraordinarily rich. And we are confident that these ideas will be moved forward by CISDL and its partners. So I hand over for the final words to Professor Marie-Claire.
Thank you as well, Professor Nandini. Your center, the Center for Human Rights and Legal Pluralism here in Faculty of Law, McGill, has truly been a wonderful partner on all aspects, even including providing us with lunch here in the faculty, which we deeply appreciated. And all the way through with your advice, your ideas, your willingness to open your, I'm old enough to say, Rolodex and reach out to very, very important speakers that we were hoping very much could join us and didn't know how to ask. So it's really been a marvelous cooperation. I can't think of better partners that we could have worked with. Thank you. I should also especially thank our network of moderators who have attended mandatory training, who have done an incredible job of flash analyzing the many comments and questions that have been coming across the chat, and then bringing them forward as much as possible in order to widen and broaden, as always, the circle. And it's deeply, deeply appreciated. So thanks especially to our online moderators and those behind the scenes who have helped with the task of organizing the symposium. I should say a special thanks to our fellowship officer, Yushi, to our communications officer, Muskan, and to our new assistant manager who jumped in with both feet to such a surprising and complex task, Carter Cheng. And more than anyone, of course, especially I'd like to thank Dr. Tejas Rao, who has been there helping us on all moments, even in the course of completing his doctoral degree with flying colors and discovering that he is now engaged to be married. He's been here until 3 o'clock in the morning, every day, helping us to pull everyone back into the fold and making sure that we are able to reach them. And indeed, in some occasions, even taking over the United Nations communication system so that the youth can have a voice in the process. So warmest of thanks and recognition to Yushi, to Muskan, to Carter, also to Fiona, who has been managing the finances, and to Dr. Tejas. It has been a real pleasure, an honor, and a privilege to work with you in the organization of this symposium. Across 4 global biennial symposia now, actually, we have asked in turn how the law might contribute to greater respect for human rights, for the global economy, and for the natural world. And today, perhaps we have heard most clearly why there has never really been truly separate questions about these issues. Despite the intense headwinds that we currently face, international law on sustainable development contributes key insights of integration and the courage to truly fulfill the duty to cooperate for sustainability, social, the economic, and the environmental cannot be seen as competing, but rather as dimensions of a single commitment to be reconciled and advanced together. This was an insight that Judge Weeramantry, in the days when I was a law student and thinking about not continuing because I was so frustrated with the learned acquis of the international law that seemed based on colonial and oppressive legal orders. And I came across Judge Weeramantry's extraordinary separate opinions, and not just in the Gabchikogu Nagimaro's case, but actually in Kasikili Saduru, wherein he posited that rather than looking at colonial structures to decide on the border between 2 countries based on mercantilism, it might be worthwhile to consider joint ecosystem management regimes. He was so far ahead of his time, and we are starting now finally to catch up, and that is deeply inspiring. Human rights are, of course, no ornament upon this endeavor. They're actually woven through every target of our global sustainable development goals and through the duties that states and stakeholders owe to present and future generations of all beings, as the Inter-American Court has said, alike. What this day has reaffirmed is that law, patiently but also courageously built, remains among our surest instruments for honoring that commitment. And in troubled times, this is no small hope. To the thousands who have registered or joined online today from over 140 countries, to every jurist, scholar, and advocate who has spoken today, to our new laureates and our new global fellow, as well as the 2 Judges Commendation Gold Award winners, thank you. You've reminded us of why our work is more than worth this effort. Wherever you are in the world, I wish you a very peaceful morning, afternoon, or evening, and I hope that our paths cross again before long in this community of scholarship, of service, and of hope. On behalf of the Center for International State Involvement Law, the McGill Center for Human Rights and Legal Pluralism, and all our partners, thank you, congratulations, and farewell.